Good afternoon, everyone. My name is Brett Liefbroer, and I am an associate attorney in Miller Johnson's Employee Benefits Practice Group. And I will be presenting to you today the July edition of the Benefits Lunch Break webinar series. And we will be talking about a new state law in the state of Illinois. But before we get to that, let me just remind you of some upcoming webinars that we will be hosting later on this year. And you can see the dates on the slides here. And on the third Wednesday of each month, we'll be presenting on a different topic in the employee benefits area that may be of interest to you. So you can register in the links that will be in the chat below. And I highly recommend that you attend. And if there are any specific topic areas that you would like to hear about, please let us know in the Q&A feature, and we will consider presenting on that topic. So without further ado, I plan to talk about today a new Illinois state law that has already taken effect as of last fall that imposes disclosure requirements on employer group health plans. So without further ado, on August 27th, 2021, Illinois passed the Consumer Coverage Disclosure Act, or CCDA, which became effective immediately as of August 27th. And the CCDA requires employers that sponsor group health plans with any employees in Illinois to disclose a comparison of the plan's coverage to certain essential health benefits required by Illinois state law. And these essential health benefits, or EHBs, are the benefits required to be covered under Illinois law in the small group and individual coverage insurance markets. And more specifically regarding the CCDA, the law requires employers to disclose the comparison to all employees eligible for the group health plan, not just employees enrolled in the group health plan. And why is the CCDA significant, and why should employers who may be headquartered outside the state of Illinois be interested in this law? This law is significant because of just how broad its application is. So the CCDA broadly applies regardless of the employer's size or its location to fully insured and self-funded group health plans. So if you're an employer, you have a group health plan, and you have a single employee working in the state of Illinois, you will be covered by the CCDA. And interestingly, in official frequently asked questions released by the Illinois Department of Labor, the CCDA does apply to ERISA-covered self-funded group health plans. So those would be any group health plans sponsored by employers other than church or governmental employers. And as many of you may know, ERISA preempts any state laws that relate to employee benefit plans. So the IDOL's reasoning as to why ERISA does not preempt this state law is that this state law is only imposing a benefits notification requirement. The law is not imposing a coverage requirement. That is, this Illinois state law does not require employers to cover any of the essential health benefits. It just requires employers to disclose a comparison of which benefits are covered to their employees. And finally, if an employer doesn't provide the required disclosure, the IDOL may issue a notice to show cause, giving an employer 30 days to comply with the state law, or as we'll discuss in a few slides, the employer may be liable for penalties. So who are the employers covered by the law? Any employer who has employees working in the state of Illinois, or as the law puts it, gainfully employed in Illinois, will be subject to the law. And there is no minimum number of employees needed for the law to apply. So if you have even a single employee working in the state of Illinois, you will need to provide these disclosures or potentially be subject to penalties. And with the increase in remote work that has become more prevalent, it is more likely that employers will have an employee working in Illinois. And so the FAQs released by the Illinois Department of Labor, they do give a few examples of when this law will apply. And so first of all, if you have a company that's headquartered in Michigan, but you have an employee that works in a store location that's in Illinois, this law will apply. Or if the employee has an office in Illinois, but frequently travels outside the state of Illinois, this law will also apply. And then, as we talked about with the increase in remote work, the FAQs list a scenario where an employee who lives in Illinois but regularly works in another state, he or she may be subject to this Illinois state law and these disclosure requirements. And the FAQs actually recommend that you reach out to your attorney in that circumstances to determine whether you need to provide a disclosure if the employee is remotely working in the state of Illinois on a regular basis. So what are the required disclosures that must be made to employees? So the employer must provide to all eligible employees, not just enrolled employees, a written list of the essential health benefits required by Illinois state law, and a statement as to whether each benefit is included under the employer's group health plan. And this information may be disclosed by emailing the information to employees, or it may be posted on a website that employees can regularly access. And so the CCDA, it doesn't specify that the disclosure must be made to eligible employees in Illinois only. However, it appears that the disclosure is only required to be made to employees who reside in the state of Illinois, because the disclosure would be irrelevant to employees who reside in other states. And I will mention that it would be helpful to have further guidance from the Illinois Department of Labor on this issue, but it appears that these disclosures only need to be made to the employees who are working in or residing in the state of Illinois. So how do you make these disclosures? So the IDOL has posted a file on their website, and it's a template disclosure form. And I have a screenshot on the next slide. And this disclosure form, it lists 42 separate benefits across 10 different essential health benefit categories. You can see a few here. So some of the categories are ambulatory benefits, which would be outpatient care that an individual may get without being admitted to a hospital, emergency services, hospitalization, lab services, mental health and substance use disorder benefits, and more. So here is a screenshot of the model disclosure form that the IDOL released last November, which will assist employers in complying with the new law. And you can see the EHB benefits and categories listed, as well as a column indicating on what page of the Illinois benchmark plan that you can find these EHB benefits listed. And the IDOL instructs employers to put either yes, no, or yes, partially in column E, which is where an employer can indicate whether the Illinois EHB is covered by the employer's group health plan. And no additional information is necessary unless the employer puts yes, partially on the employer plan covered benefit column. So for example, if a group health plan provides up to 3 months of rehabilitation for an employee after the employee has a stroke, but the Illinois EHB requires coverage for 6 months of rehabilitation, that would be a circumstance in which yes, partially should be listed in column E. And Illinois' access to care and treatment plan serves as the baseline for the minimum scope of benefits that most health plans sold in the individual and small group markets must cover at equal or greater value. And since the inception of the Affordable Care Act, federal guidance has allowed each state the opportunity to select from 10 base benchmark plans, which Illinois has selected from. And I did receive a question before the presentation, and it said, this particular employer reached out to their insurer to see if they could support the requirements under the CCDA, and received a response from their employer they received a response from their insurer that the insurer was working on the requirements of the law. And this particular question asked, are there any suggestions for how to address the requirements of this law on our own, so without the assistance of an insurer? And my recommendation would be to download this template disclosure form and to look at it and determine whether you have the knowledge within your organization or by looking at your insurance policy to determine whether you can fill out this form on your own. If it turns out that you don't have the knowledge to prepare this form, you'll need to rely on your insurer or your third-party administrator to complete the form. If you do have the knowledge to complete it, you can go ahead and do so. And then, as I mentioned earlier, if the Illinois Department of Labor suspects a violation of this law, they will issue a notice to show cause, which will give you 30 days to comply with the disclosure requirements. And in that case, if you receive one of those notices, you can forward that on to your insurer or TPA and let them know that this is an urgent scenario where if they're working on it, they need to complete it so that you can comply with the disclosure requirements. And I did receive one question in the chat here. Would we be able to disclose this in our payroll system like ADP or Paycom? So as mentioned earlier, this disclosure can be made in an electronic form. So for example, by email or posted on a website. So assuming that your employees have regular access to your payroll system, so ADP or Paycom, and they can get into that system and see this disclosure, yes, you would be able to post it there. Okay, so timing of disclosures. So these disclosures must be provided to eligible employees upon hire, each year thereafter, and upon request from the employee. So we are recommending that the annual open enrollment period is a good time to provide the required disclosure for purposes of the annual disclosure requirement. And the law also requires that employers must keep documentation that each employee has received the required information for 1 year. This slide lists the penalties for non-compliance under the CCDA. And the penalties increase for each offense or violation and depend on the employer's size. So depending on how offense or violation is interpreted, the penalty could be relatively small, or it could quickly become a large amount. So on the previous slide, I mentioned that employers must provide these disclosures upon hire, each year thereafter, and upon request. So for example, let's say an Illinois employer with all of its employees located in Illinois loses track of this law or never discovers that it exists and never provides the disclosures to its employees. So is the penalty imposed each time the employer hires a new employee? Or additionally, is a penalty imposed for each employee who doesn't receive a disclosure at annual open enrollment, or is only one penalty imposed for all employees missed during the open enrollment period? again, this is a situation where we're hoping additional guidance from the IDOL will be issued to determine, is there one penalty issued for all employees at open enrollment, or is there a penalty that's applicable for each specific employee that doesn't receive a disclosure? And I'll also mention that the IDOL has discretion to determine the exact amount of the penalty based upon the facts and circumstances. So these penalties may be mitigated based on good faith efforts to comply with the law and the nature of the violation. And also, an employer may apply for and obtain judicial review of any order issued by the IDOL. And the issue of ERISA preemption is also what makes this law so interesting. So as of right now, it is unclear whether ERISA preempts the CCDA. And as mentioned before, the IDOL has released guidance stating that the new law applies to all group health plans, including ERISA-covered self-funded group health plans. And until this issue is litigated, the application of ERISA preemption to this state law is uncertain. And employers that are sponsoring ERISA-covered self-funded group health plans that have any eligible employees, the conservative approach is to comply with the CCDA's requirements until there is more certainty on this issue. And I did take a look this morning, and as of today, I have not seen any employer lawsuits challenging this law on the grounds of ERISA preemption. So we'll just have to wait and see if any employers decide to challenge this law and challenge it in court on the ERISA preemption issue. But until then, the conservative approach, even for ERISA covered self-funded group health plans, is to comply with the law. And I did receive another question in the chat, and it says, we have seen a lot of pushback from insurance carriers on assistance with filling out this form and its accuracy, and the insurers are not assisting. So as I mentioned earlier in the presentation, if the insurer or third-party administrator is not assisting, you can take a look at the template disclosure form that the IDOL released and look at it and see if you have the knowledge within your organization to complete the form. And if you don't, all you can do is push back on your insurer and third-party administrator to complete the necessary disclosure. And again, the IDOL will issue a notice to show cause if they suspect a violation of the law. And at that point, you will have 30 days to comply with the disclosure requirements. So if you receive one of those notices, you could definitely forward that on to your carrier and say, hey, the clock is ticking now. We need to complete this disclosure. And now we have a timeline. And that may prompt your insurer or TPA to complete the form. So one additional question: it is the employer's or plan sponsor's responsibility to complete the template grid and provide it to the employee who resides in Illinois, or are carriers on the fully insured plans providing this grid? So as you can see on the third bullet point on this slide, ultimately it is the responsibility of the employer as the plan sponsor and plan administrator to comply with this law. But you, in some circumstances, if the knowledge to complete the required disclosure is uniquely within the knowledge of your insurer or TPA, you necessarily will be reliant on them to complete the disclosure. And we also received a question: what happens if you have multiple health plans with different coverage? So this is addressed in the Illinois FAQs, and those FAQs state that if you can provide an accurate and not misleading disclosure on one Excel file, basically the template required disclosure form, you can provide that disclosure on one form. But if you have different health coverage options that are drastically different from each other, you may need to complete multiple files for those different coverages, especially if they're covering different essential health benefits under the Illinois state law. Another question states, we have employees in all 50 states, but only 7 part-time employees in Illinois. Part-time employees are not eligible for our self-insured group health plan. Does that mean we do not have any obligations at that time until/if when a full-time employee is hired who resides in Illinois? So this law applies, and the disclosure must be made for any employees who are eligible for the group health plan. So with this specific question that we received, the part-time employees who reside in Illinois are not eligible for the group health plan. In that circumstance, the required disclosures would not need to be made. Again, the disclosures only need to be made for eligible employees who are residing or working in the state of Illinois. So what can employers do now to comply with this law? So as we've talked about, if you're a fully insured plan, you can reach out to your insurer, and just based on the questions we're receiving, it sounds like some insurers are taking their time to get up to speed and produce these disclosures. And if you're a self-funded group health plan, you can reach out to your third-party administrator for assistance with these laws. And there are basically 2 options right now with respect to this law. So if you have an employee eligible for your group health plan who is working in Illinois, you can, number 1, you can comply with the CCDA now, or number 2, you can take a wait and see approach and see if this law is challenged on ERISA preemption grounds, if you happen to be an employer that is subject to ERISA. Or additionally, it looks like you can wait to comply until or if you receive a notice to show cause from the IDOL, which would give you 30 days to come into compliance with this law by providing the required disclosure. And taking that last approach may be a risky approach under this law, because you'd be putting yourself on a potentially tight deadline to produce the necessary comparison and provide it to your employees. So with all of that said, I will just mention that this law is interesting just because of how broad of an application it has. If an employer even has a single employee in the state of Illinois, this law is going to apply. And this law is one of the first of its kind of having such a broad application and even applying to plans that are covered by ERISA. So employers should just be aware of the law, even if they don't have any employees located in Illinois, because other states may see what Illinois has done here and try to pass similar laws. So it's a circumstance where it could be a first of its kind, and it should just be on the radar of employers. So with that said, I don't see any additional questions. If anyone has any specific questions related to this law, they can reach out to me. You'll see my contact information on the slide here. And additionally, if anyone is interested, we will be hosting another benefits lunch break webinar series in August, on August 17th. And I encourage everyone to sign up if they have time. Thank you for attending today.